Buckle up, guys. Today we are diving into a courtroom saga that only gets wilder by the minute. Right from the start, the host frames this as more than just another hearing. It's a continuation of chaos. We're told this defendant has been here before, but now he's escalated things by claiming he's a government asset. The stakes feel bigger, the tone sharper. Before we even enter the courtroom, we already sense this won't be routine. It's the calm before a procedural storm.
The arraignment is your true and correct name, Sylvester Larnell Evans.
Sylvester Larnell Evans Jr.
And what is your date of birth? Earlier we went over your rights to arraignment. Any questions about your rights to arraignment that I wasn't able to answer?
No, I don't have any questions, but I would like to speak with the judge if possible.
You'll get it in a moment.
What is the city's recommendation regarding release?
The city is requesting bail or bond amount of $500 on each of the 6 cases. Defendant has a significant warrant failure to appear history, including 1 active warrant out of Tacoma Municipal Court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail or bond on the 2 review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption administration of justice.
Any objection, Mr. Iannotti?
Yes, ma'am. I would like to speak.
Just a minute. I'm going to talk to your attorney for a second, and then if you want to say something and it's okay with your attorney, I'll hear it then.
Mr. Evans, I indicated that he did want to say stuff, and I told him he could, and he also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
Okay. All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appear, but if you give me a chance at a personal bond this time, I want to deliver a letter to you hand to hand. I will make the court date because I want to deliver a letter with a message to you hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where I'm getting mistreated. I'm on 23-hour lockdown. I'm on crutches. I have a leg injury, and it's extremely difficult and mentally strenuous, the things that they're doing to me inside of the jail. That's why I say I want to, if you give me a chance at a personal bond, I assure you I will appear with the letter in my hand for your insight, as well as attention to Chief Justice Roberts, so he can be alerted to what's going on.
You have 17 warrants out of our court alone.
All right, guys, this is where the first sparks fly. What begins as a standard arraignment quickly shifts when the defendant asks for release so he can personally deliver a letter to Chief Justice John Roberts. That's not just unusual, it's a massive leap beyond the scope of this courtroom. The prosecution highlights 17 prior warrants, instantly undercutting his credibility. Yet he insists this time is different. You can already see the divide forming between courtroom procedure and his personal narrative.
Your Honor, that I will appear. I want to...
Sir, with all due respect, you just don't come back. You have 17 prior warrants out of our court. It is your duty to keep your address updated. I think $500 each case is very reasonable to ensure.
I can't afford that at the moment. That's why I was asking for personal recognizance. If you give me a chance, I assure you I will be there, because I want to prove that I'm innocent of these charges, and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg, and it's messing with the muscles and nerves because I need to keep my leg active and in motion, and they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal Court.
I'll resolve that as well, because when I went to court, they initially told me it was dismissed. So I guess they just put something back out. I'll resolve that as well. But if I humbly and respectfully ask that you please give me one chance to prove myself, please, because it's almost unbearable for me to represent myself and with my leg injury and the conditions they have me in, and me getting mistreated in the jail as well.
Okay, I've made up my mind. I'm imposing bail in the amount of $500 each case. And I will appoint Mr. Ainati while you're in custody, so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way.
Ma'am, that's the whole thing. Point I was trying to make. Mr. Ianetti is not properly represent me. That's why I want to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm not forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me, and I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many eyes that's gonna see it. In addition to that, the circumstances and the conditions they have me in, and I'm in a cell to where there's no access to the kiosk where I can look at the law library. In addition to that, I'm in a
Mr. Ainati, when would you like to set this over till?
Thursday.
All right, Mr. Evans, we'll see you back here on Thursday.
Would I be able to request a PR bond at that time, or is everything?
No, you're only entitled to one bail hearing unless there's been a change in circumstances.
What about the jail conditions they have me in? I'm in 23-hour lockdown. I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Ainati while you're in custody, and or at the very least a standby counsel. You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ianetti give me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well.
Yes.
Well, you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Ianetti this, he never made any motions to get the process started. That's why
there is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself. And
that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll accept
gonna-
it.
With him because he's in custody right now. I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
I
Got
would
it.
like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I can get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I sent the proof in the letter that I mailed
No,
out.
it wasn't provided to the city. I haven't seen any proof. And I would say that's not a change in circumstances.
I mailed the letter out
What
on.
was said?
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affecting my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it.
At this point, the strategy pivots. Instead of focusing on the charges, he shifts to jail conditions, lockdown, injury, lack of access to resources. He ties these hardships to his desire to represent himself and again pushes the sealed letter narrative. But the court calmly explains procedural rules. Anything filed must be shared with the city. His attempt to create urgency through secrecy clashes with the transparency courts require. The frustration builds, but the ruling stands firm.
And Ms. Chenmuller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fighting history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport. We have 4 pre-trials and 2 reviews involving those allegations, the same
And
allegation
in
before
addition
the
to
court
that,
today. Has warrant fighting history in pretty much every case.
What is his date of birth? I'm trying to find him on Jax.
my last name is Evans, it's not Williams.
It is 6/7/84.
And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday
And I-
as well.
And also, I never invoked my right as a Native American Indian chief. This time I did, so therefore I will not miss not one court date, I assure you. Can you
I'm
please?
not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States. I've put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case. Since I was not the judge on Monday, I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're gonna set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. Could you please put on note that I asked that it be sealed?
Here we see the hearing winding down, yet the resistance continues. He asks if jail conditions qualify as changed circumstances to revisit bail. The judge clarifies the limits: one bail hearing unless something materially shifts. He demands a speedy trial, suggesting prior counsel failed him. The court explains the clock already started. This exchange highlights a recurring theme: misunderstanding procedure while insisting the system failed him.
Object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna... No, ma'am. Could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you've provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter, or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All
The
right, well,
city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean, if
I
we're
mailed
setting
it.
it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
no, we are not ready to address that today. So we will
Okay.
address these matters again on Wednesday, May 20th.
Now the pre-trial conference escalates everything. He formally invokes his status as an Aboriginal Native American Indian chief, claiming sovereign authority. This is no longer about bail alone, it's about jurisdiction itself. He asserts that his identity grants him constitutional protections beyond the state's reach. The courtroom, however, remains grounded in established law. What he presents as a transformation in status, the court sees as unchanged circumstance.
Fire my lawyer on
You
standby.
don't have a lawyer, remember? We've already been through this, you represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
No, I'm
please.
not gonna do that. What's the basis for that?
Because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like, I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates,
Correct.
which will prolong my time in jail,
I don't know that.
possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail.
Mr. Evans, do you want me to represent to the court what we had discussed? I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for?
I'm gonna write a letter to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send 2 different letters.
Yes,
I mean, I have to make a copy of it and
Correct.
send. I have no way of making a copy from inside the jail.
you'll have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send 1 letter. They in the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm gonna mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you are having ex parte contact if you send something only to the court and not the city.
I'm not in, what, can you tell the jail, give me sufficient paper so I can make 2 copies? Because they're not giving me the what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ainati, and then he can make copies for both the court and the city.
Okay, Mr. Ianetti, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ianetti.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans, and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena the Apostle Derry G. He believes that they're all witnesses for this case or these cases that need to be brought in. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said,
2412.
that's a matter of secret state privilege. I don't want you discussing that.
Okay.
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ainati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000, nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is gonna exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will possibly exonerate me.
Is the city seeking any restitution?
I definitely stated that in the letter, and I asked I made that clearly known to Mr. Ianetti if he's doing
Sir, you can't get restitution. I don't know what the basis is for restitution.
If I'm found innocent, I would like restitution for my businesses for each day I sat in jail and they lost potential money.
There is a rule that provides for that is not restitution in the sense that it would go to federal court. This is not a federal. There's nothing in here.
The amount that I'm asking for.
That has nothing to do with it. That's a separate issue. Is the city aware of any issue that would cause this case to be removed to federal court?
No.
And not even my right.
This is the philosophical breaking point. He claims tribal sovereignty, federal immunity, and removal to the highest court in the land. The commentary even highlights confusion surrounding his medical claims, symbolizing the broader disconnect. The judge questions how any of this affects his obligation to appear. His argument rests on imagined jurisdictional borders, while the court operates within recognized legal structure. Its ideology colliding with institutional authority.
Asserted that you are a tribal chief. I have seen no evidence of that being true. Just because you say it doesn't make it true.
I gave you the proof, but you needed the physical case in front of you, which has a seal on it. So even if it's in front of you, you still won't be able to see that I'm a tribal chief based on having a case in front of you.
It's my understanding that Mr. Ainati was able to obtain that document.
Correct, which is a matter of secret state privilege.
So you can't say it's in this document and then not let me see it.
I'm just stating facts. That case is a matter of secret state privilege. So that would be grounds. Would that be grounds to get it transferred to federal court?
The issue is whether you trespassed at the airport, sir. That's the only issue.
I understand, but as a tribal chief, I have the right to have any grievances between me and the state heard before the United States Supreme Court due to me representing a sovereign state that's federally and internationally recognized, a sovereign tribe that's federally and internationally recognized.
You won't tell me the name of the tribe. You won't show me the document.
It's a matter of secret state privilege, Your Honor.
You can't have it both ways.
I'm just stating facts. It's a matter of secret state privilege.
So no, this, as I understand it, the city is not willing to transfer this case to federal court.
Mr. Arnett, I would like to appeal anything that's being declined. I just want to get this on the record that I want it appealed. Anything that's being declined, I want it appealed.
Sir, you represent yourself. It's up to you to appeal.
Okay, no problem. I'll send a letter out today with a notice of appeal to the Supreme Court of the state of Washington.
Appeals from courts of limited jurisdiction, which is what we are, go to Superior Court, not the Supreme Court.
But I'll try to speak to them based on the circumstances that I would like to oblige directly to the state Supreme Court due to the circumstances and the fact that it's connected to a matter of national and homeland security.
You're going to have to show them proof that that's the issue too. You can't just say a thing.
I will show them the proof. I will show them the proof with no problem. It's on them if they want to do their work and research and diligence to get the answers that they want, that they seek.
So,
I will show them the
proof. Once again, courts are not investigative bodies. They will do no research. They will not do an investigation. That is up to you.
I understand it. Exactly. And I'm doing an investigation on my behalf, and I'm providing everything that they're asking me for. They just don't like my answers. I'll deal with that on the federal level when I file a notice to remove once I get out of jail, because I can't do. Also, if Mr. Iannetti, if you can file a notice to remove with the federal courts or with this court, I would like that as well.
Do you have any concerns about Mr. Evans' ability to proceed?
I do. I mean, I don't have anything to verify any of the claims that he has made and the information and who he's asking for as far as witnesses in this case lead me to believe that there may be issues.
Do you think it's appropriate to have him evaluated under 1077?
I do.
Does the city have any objection to the ordering of that evaluation?
I have an objection.
Okay.
Can I object?
You can object.
Yes, ma'am. I assure you that I'm 100% competent, and I assure you that everything I'm saying is true. As far as civil case 24012 out of St. James Parish, Louisiana, that is a matter of secret state privilege, and it also verifies the facts that I'm making that you guys claim you cannot prove.
But you won't let us see it.
Mr. Iannetti has to get the case himself.
He has it.
So tell him give it to you.
Can I identify the case, Mr. Evans?
Civil case 24012 out of St. James Parish, Louisiana.
Can I identify the case and the information that I have?
Like I said, you can give her civil case 24012 out of St. James Parish, Louisiana. If she wants to look over it, it has a seal on that case. So you're going to have to get permission to get that seal removed.
So it's my understanding
true content.
It's my understanding it does not have a seal.
That's the information that I have is it does not have a seal. It's a 1996 case, Blue Harvest Maritime versus Opal Evans. It was a suit for damages.
That's the guise that it's under, but the true contents of that case is under seal. I assure you.
And Mr.
I guarantee it. I'm not guessing.
Who can take it out of seal.
I'm not guessing. I'm guaranteeing it because I became the chief of a federally and internationally recognized tribe when my father passed in 1993, and everything was made official with that case in 96.
And finally, the judge delivers a steady conclusion. After reviewing his record, she finds no basis to modify bail. His motion to dismiss for lack of evidence cannot proceed without proper filing. Even his mailed letter hasn't been received. What he frames as constitutional crisis, the court treats as procedural deficiency. The hearing closes not with drama, but with structure intact. Despite every argument raised, the system remains unmoved.